Hi, everyone, and welcome to this week's episode of our live webinar series, proudly presented by ImmigrationQuestion.com, your go to source for up to date immigration information, trusted attorney insight, and real time conversations about today's most pressing immigration topics. My name is Anasia Mukherjee, and I'll be your host for today's webinar, Navigating Asylum Claims Amid Political and Humanitarian Crises in 2025. Now, more than ever, the world is watching global events unfold at an extraordinary pace. From violent crackdowns on dissent to ongoing conflicts, climate displacement, and targeted gender based violence. More people are fleeing for their lives and seeking safety here in the US. But while the need for protection grows, the legal pathways are becoming more complex and harder to navigate. That's why today's session is so important. We're here to talk about what's happening now in asylum law and how to respond to these changes, and what you and your clients can do to move forward with a sense of direction and dignity. We are honored to be joined by attorney Laura Mahabir, Bali Mahabir, an experienced immigration attorney and former DACA recipient whose personal journey through the U.S. immigration system gives her a unique insight into what her clients face. Attorney Bali is a graduate of New York Law School, and her practice is built on a powerful combination of professional expertise and life experience. Attorney Bali, thank you so much for being here today.
Thank you so much for having me. I really appreciate the opportunity to speak to everyone that's here. And whenever you're ready, we can get started.
Thank you. Before we get started, just a quick reminder, Immigration Question is a platform that connects users to licensed immigration attorneys. We are not a law firm, nor are we affiliated with AILA or USCIS. All legal services are provided independently by attorneys registered on our network. So let's dive into the questions. Attorney Bali, let's start with the fundamentals. What qualifies someone for asylum in the United States, and how does the current legal framework define persecution in 2025?
So there are the basic requirements where I'm pretty sure most people know that you have to have been persecuted based on one of the five protected grounds, which is race, religion, political opinion, membership in a particular social group, or nationality. That is directly from the Immigration and Nationality Act. And also, you have to apply within 1 year of coming to the United States. One question that we do have a lot is whether or not, like if individuals come with visas, when does the 1 year clock start? And for the most part, it is within once you enter and or a reasonable time after you become out of status. Also, you do have to have a well-founded fear of future persecution. If you're persecuted in the past and you establish that with your the evidence you submit to the judge and to the department, you then have a rebuttable presumption for well-founded fear of future persecution. The department can only rebut that showing that you could have reasonably relocated within your country and been safe, or that there were a change in country conditions so much so that you can now return to your country safely. Regarding to the type of how does the legal framework define harm, the harm has to rise to the level of persecution required for asylum, which is a 1 in 10% chance of that you would be harmed if you were forced to return to your country. And unfortunately, it cannot just be a mere harassment or discrimination. It must rise in the totality of the circumstances to persecution in their definition. Also, it so when you apply for asylum, you apply for asylum and then also withholding of removal and the Convention Against Torture in alternate methods of relief. The in those the withholding of removal and Convention of Torture, the eligibility for asylum depends on the level of persecution that you face. So it must be more likely than not you will be tortured for the Convention Against Torture, and it has to be more likely than not that you would be persecuted for withholding of removal. So that becomes a 51% chance instead of the 1 in 10 chance that asylum provides, which obviously is a lower burden and it's harder to get the withholding of removal and Convention Against Torture. Also, the government must be unwilling or unable to control the individuals who harmed you. And it could be members of the government, not disposed of, but the members of the government that the to be persecutors that the government facilitated on their own, or if it is non-state actors, which is private parties, then you must submit proof that the government was unwilling or unable to control those individuals. So it would be like if you went to the police and the police took a report but no evidence was submitted, then no, I'm sorry, no evidence was submitted. If there were no actions taken by the police, then you can submit a copy of that police report. However, we do have situations where individuals go to the police and the police just refuse to take the claim or to take the complaints. In those situations, you can submit your affidavit saying that you did go to the police after you were attacked or threatened or harassed and that they refused to take the complaint. You could also have, if family members were with you, you can also submit affidavits from them stating what happened at the police station. And then you can always submit country conditions articles showing that the police in your country of origin or the country where you were persecuted were have a tendency to not help individuals who were attacked by this specific group. Additionally, you can't be barred from asylum, so it's the basics. You can't persecute anybody else. You couldn't have committed a serious non-political crime. You can't be considered a danger to the United States. Um, Also, you couldn't have previously filed for asylum and then it was denied, unless its circumstances in your country have changed so much so that you're now scared that risk to your life now is more heightened. Now, the two that I've really seen that's been a bigger issue for respondents or clients in removal proceedings would be if they firmly resettled in a third country before coming to the United States, which is not usually a problem for individuals who have come with a visa because they usually take a direct flight from the country to the United States. However, for those who transited through the various countries and came into the Mexico border, the issue arises sometimes where they would spend a month or 2 months in some of these countries. Obviously, I know it's not in their control how long they spent in these countries, but unfortunately, the department and the government and the judges tend to find that that is considered firmly resettled.
Mm-hmm.
The department will make that argument that it's considered firmly resettled since they spent so long in that country. And then there's also situations where individuals actually resided in the country for more than a year and they worked and they opened businesses, then that's definitely a firmly resettlement bar. Additionally, the other one that I've seen that's been coming up with more recent claims would be something that was brought out under the Biden administration, which is the circumvention of lawful pathways. So basically, if you cross the border after May 11th, 2023, you have you're barred from asylum unless you use the Customs and Border Control app. I think it was called CBP 1 at that time. It's been discontinued since the Trump administration. However, now that law is still in effect that you're barred, and the only option you have is that either you use the app, you had an extreme threat to life, or you have, or of course, if you are unaccompanied minor and you're applying for special immigrant juvenile status, that is definitely also an exemption to the bar. And also, one that we've recently discovered is under the Family Unity Act, if you cross the border and you have children or a spouse in the country of origin or the country where you came from, and you can prove that you're eligible for withholding of removal, which, like I said, is the more than likely or not chance that you would be persecuted. It's the higher burden than asylum itself. If you prove that withholding of removal, then you become eligible for asylum, and that is the only way that you would get asylum.
Thank you
I
for
actually
that.
have a PowerPoint, and I'm not sure if it's showing. There we
It's
go.
showing now.
Yes, thank you. It's not sure.
All right, perfect. It's showing up.
Yes, so this was the. So this was the one that I just spoke about. I just want to present it in like the fuller. So everybody can see it this way, right?
Yes.
Awesome. So like I said before, it's the must apply within 1 year of entry. You have the well-founded fear of future persecution. The persecution must be based on a protected ground, which is race, religion, nationality, political opinion, or the PSG. And that well-founded fear of future persecution goes hand in hand with an objective fear. and a subjective fear of return. So the objective fear is the 1 in 10 chance of persecution that I spoke about before, and that's the objective fear. The subjective fear is the genuine fear that you actually are scared. You have to prove that you are genuinely scared to not return to the country. And that's all for that question.
Thank you so much for that insight. So, we've seen multiple global crises unfold this year, from political crackdowns to humanitarian disasters. How are these events influencing the type of asylum claims you see most often in your practice?
So, give me 1 second. Basically, the system overall, it's gotten a lot stricter and tougher to be given an asylum now than it was before. There is definitely a need for more extensive corroborating evidence, because in the event that you are found adversely credible during your hearing based on your testimony or your based on the way the department questions you, your that adverse credibility finding, you can be rehabilitated from it based on your corroborating evidence. So if you have enough corroborating evidence to show that even though you didn't have even though you had some minor inconsistencies or omissions, your documentation shows the correct information, then you can be rehabilitated. And that is really the most common thing with asylum applicants, is just that it's a very nerve-wracking process, especially now because there's so much more on the line. And a lot of times the hearings are in person now, and there are ICE officers in the building, right at the elevators when you come into the 12th floor. At least I know that's how it is for Federal Plaza. So it's definitely a more stressful situation for applicants, and it does affect their mental health and the way that they answer questions. So would definitely say make sure to have enough corroborating evidence. Also, the number of asylum claims that are coming in from the border, they have naturally decreased because the border is now closed. And we do have one or two, I think we actually have about 5 or 6 cases where the clients didn't manage to make it through the border. And this is not me saying that you should try to come through the border, because those clients are in detention, and it's been a lot harder to get them out of detention than it was before based on the current case laws. And also there's many more cases going on to appeals to the Board of Immigration Appeals because they're getting denied at the immigration court level. And unfortunately, the BIA is the one who has to rule on them.
That's understandable. Now, I understand asylum law is notoriously complex and it's constantly shifting. Can you highlight a few major changes? And I know you mentioned this, but just to summarize, a few major changes or trends in the US asylum policy that applicants and advocates should be aware of in 2025?
Yes. So on the PowerPoint, I'm not sure if everybody can see. I hope everyone can see it. I already highlighted a few of them. So one of the most important ones is a BIA case that came out, I believe, in April of this year, 2025. It's a matter of CARR. Basically, this case is from the BIA, and it says that the immigration judges can't terminate asylum applications based on the finding that it's an insufficient asylum application, meaning like it was not submitted with your identification documents as the 589 recommends but doesn't require. If your questions later, not the beginning of the asylum application, but the last few pages, I believe from like page 5 or 6, they ask you more in-depth questions about the persecution you faced, what countries you traveled through, who harmed you, what parties, what groups were you a part of, why do you fear returning to your country. If those questions are not answered correctly, the immigration judge can terminate your asylum application or order you removed. And shortly after, actually it was April 8th, I think that decision came out, and then on April 11th, the Executive Office of Immigration Review, which is the entire the immigration court system, they posted a memorandum basically saying that judges are now allowed to terminate legally insufficient asylum applications if they feel it's necessary to clear their dockets. So basically, if you are given this chance to apply for asylum and you do not give them all the required documents, they can order you removed. and terminate your asylum applications. And these two things together, separately, you do have an argument. You can overcome it. However, together, it's basically a very hard burden to overcome, or it's something very hard to circumvent. So the only way to really make sure that you're not ordered removed or your asylum application is not pre-terminated is to submit the application properly and with your identification documents, and to make sure, so the I-589 has application instructions that are easily found online. And if you are representing yourself pro se, as many applicants do in the beginning, they have every single language on the USCIS website. They have those instructions in every single language. So make sure to read them so that you can know that you're following those instructions, and that so they will not order you removed. Another one that we found recently, this is more for detained cases. It was again in this year, it's a matter of QLI, which basically says that in certain situations, the immigration judges now lack jurisdiction over bond decisions. That means if a client is detained, they cross the border. Like I mentioned, we do have a few of them in our practice here. If they are detained, immigration judges do not have jurisdiction to grant bond, which means the only people who can give you a bond or parole would be the Department of Homeland Security, who have now, I believe, been instructed to not actually give out bond or parole. This has been my experience. I'm sure there are some cases where individuals are being released. However, it's very hard to be released from custody once you have been taken in. Also, some other trends that we have found, it's also if you entered with a visa, or if you entered across the border, they issue you a notice to appear when you enter across the border. Well, they're supposed to, and they're supposed to docket that notice to appear, send it to the immigration court. Now, we have had a lot of situations where they don't docket it immediately, and in that event, we apply affirmatively with USCIS for these applicants, and also if they entered with a visa, we apply affirmatively with USCIS instead of defensively. So what we found is recently, they will accept the initial application, USCIS, but then after the 5 months, when they go to apply for the work permit, they actually administratively close the 589 application and deny the work permit, because they're saying that USCIS has no jurisdiction of this case because they are technically in removal proceedings because an NTA was issued. However, the current case law and the statutes state that when that NTA is sent to immigration court, that is when the immigration judge only has jurisdiction. Before that, USCIS does have jurisdiction. However, it is a way of them trying to request that individuals speak with ICE to do new credible fear interviews, which are usually done at the border. However, if you weren't given one, or they want you to do a new one, they terminate they administratively close the asylum application. They don't give you your work permit, and they said the only way that you can basically have your case docketed now is to do a new CFI, which credible fear interview, which requires you going to ICE and reporting to ICE yourself. And in many of these cases, the clients are in expedited removal proceedings. So if they have no relief pending, then they can be taken in by ICE when they go in for that credible fear interview. Also, as I mentioned before, with the termination of the asylum applications, even if you have a nice judge who doesn't want to terminate your asylum application, or doesn't bring up the option of it happening themselves, the department during your master calendar hearings can move to pre-terminate the asylum applications, and the judge's hands are tied at the moment. They have to follow with what the case law is saying, because at the end of the day, they are also doing their jobs. And if the department asks for this termination and you qualify for this pre-termination, then you risk getting your asylum application will be deemed abandoned, and you will be ordered removed on the spot.
All right, thank you for that. Let's talk about the beginning of the asylum process. What should someone expect during their credible fear interview? And why is that part of the process, and why is that so critical?
So the credible fear interview is part of the process because the government has this idea that if you have a credible fear when you enter the border, that is the closest time to the events that happened to you when you were persecuted. So that is actually given more weight than even your testimony or your statements or your family's affidavits, your friend's affidavits, your medical documents, anything you submit for your individual hearings. That credible fear interview is given more weight because it is considered closer in time to the events that happened. And this is a very important part of the process because initially, now, well, not initially, but before Trump, when you entered at the border, you had the CFI, and the CFI, if the department or ICE at the border, they use this interview to determine whether or not you have a well-founded fear to return from returning to your country. Now, this is important because if you don't have that well-founded fear and they don't find that you have that well-founded fear, they can either place you in expedited removal proceedings and you can be sent back immediately if they find that you do not have this well-founded fear. Now, the types of questions that I found reading over the transcripts from the clients that we have is they basically ask, your basic identification questions: your name, where were you born, your date of birth, your parents' name, your siblings' name, where they were born. However, the questions do get a bit more detailed. So as I have here, they definitely ask you about the harm that you faced, who harmed you, the dates that you were harmed, what happened to you, did you go to the police, did you go to the hospital, what injuries did you incur. And what I found is when it gets, even if you pass that credible fear interview stage, when you get to the individual hearing, if you bring up new information, that is considered that you omitted information at your credible fear interview, because as I said, it is given more weight. And because of that, you can be found adversely credible. And a lot of clients will say, well, they didn't ask me about this directly, so I didn't answer. I didn't tell them, which is a fair analysis of what happened. However, in this day and age, that's not a risk that you should be willing to take. So I would definitely say whenever answering these questions to be as detailed as possible. Even if they don't ask you the questions outright, give them that information because you don't want it in the long term that it comes back to bite you. Additionally, a lot of clients will say, well, okay, well, I wasn't in a mentally, well placed when I was doing the credible fear interview. However, again, you're just saying at the individual hearing, like, hey, I wasn't in a good mental state. That doesn't really provide the court any type of substance to give the credible fear interview less weight. It has to be backed by a medical evaluation. So if you're released from custody shortly after, you should do a mental evaluation to show that you can submit to the court that's like, shows you suffered trauma, yes, and you were having memory issues. Other than that, I would say, like I said, make sure to give as much information as possible.
Thank you for that. To our amazing audience, thank you for joining us. Whether you're tuning in from Facebook, YouTube, or LinkedIn, we're thrilled to have you here. We are immigrationquestion.com, a two-in-one platform built with lead and case management features to help simplify the immigration process. Though we are not affiliated with AILA, we are trusted by a lot of AILA attorneys who use our platform. You can ask your immigration questions for free in any language and get connected with the licensed attorney for guidance. You may also receive a free confidential initial consultation. Just visit www.immigrationquestion.com and sign up today. And in some exciting news, we've just launched our new app built to serve both attorneys and users seamlessly. Now, Attorney Billy, as an experienced immigration attorney and even a DACA recipient yourself, what do you think about what immigrationquestion.com is doing for the immigrant community and even for immigration attorneys like yourself?
I think it's something very helpful because even when I was going through the process myself, I'm now a naturalized US citizen, but even when I was going through the process myself, it's very hard for us to understand as, individuals who are not legal professionals. It's very hard for us to understand exactly what's going on and what all the legal jargon means. So it's helpful that you guys are, here and available to for people to ask questions, whatever they'd like.
Thank you. If you're joining in, we've been having a very educational session with Attorney Bailey on the topic navigating asylum claims amid shifting political humanitarian crises in 2025. We're just getting to our live Q&A session. This is your chance to ask Attorney Bailey your own questions directly. Just type them in the chat or call us on 516-703-3483. All right. First question is, my asylum application has been pending for over 2 years. What's causing the delay, and is there anything I can do to speed up the process?
So that should be one away if you'd like to speed up the process right now, because it depends what state you're in and the chance you have of winning your case. However, it could be a variation of things causing the delay. And I don't have all of your case information, so unfortunately, I can't give you a complete answer. But for what we've seen, for the most part, it's sometimes cases just get stuck in the trial queue because immigration court is backlogged. Like I know in New York, they have so many cases, it is definitely backlogged and they get stuck in the trial queue. If that's your situation, then you can submit, if you have an attorney, your attorney can submit a motion to set an individual hearing date stating that your case has been pending for over 2 years and you would like to set it for a date, and the judge will keep that in mind. Right now, I believe they're out to 2028 or 2029, so even if you get a hearing date, it won't be like tomorrow. But it can definitely help when the judges have openings, they'll put you in for it.
All right. Next question is, I survived a forced marriage and female genital mutilation. How do I ensure the asylum officer understands the cultural context of what went through?
So I am sorry that you went through that. And I will say that you can definitely, it depends where you're from. You can submit country conditions articles showing that other women also went through this at your age, and also you can do affidavits from yourself. You can also have a psychological evaluation done by a mental health professional or especially a doctor, and submit that to the court, or you said asylum officer. So I'm not sure if your case is actually in the court or if it's with USCIS. However, in both cases, you can submit affidavits, you can submit mental health reports, you can submit country conditions articles so that they understand.
Perfect. Next question. I lost all my documents while fleeing my country. Can someone still win an asylum case without any physical evidence? What can help support my case instead?
I am sorry you lost all of your documents. It is possible to win your asylum without any physical evidence. There is case law that says if the judge finds you credible, you the need for cooperating evidence is diminished. However, I will say do your very best to find those documents, even if it's copies, if it's calling family overseas, you should get it because, like I said, if you were found adversely credible, especially if you had a CFI at the border, those corroborating documents, which is your physical evidence, can help rehabilitate you and support your claim. What can help support your case instead? Well, I'm not sure what ground you're applying for asylum on. However, like I said, you can always submit country conditions reports. Those are articles that can be found online. Or if you don't speak English, you can also find articles from your local newspapers from your country and have those translated to submit as well to show that you do have that well founded fear of future persecution and that the conflicts in your country are ongoing. And as always, you can do I always recommend a mental health evaluation from a doctor because that always helps to show that you did suffer some type of trauma, whatever it may be. And you can also get expert opinions from experts and from your country, like experts on your country, the political or the country conditions in your country, and they can do that. Unfortunately, I'm sure they do charge a decent amount of money though for that. So just keep that in mind.
Next question is, I followed all the rules and provided testimony, but my claim was still denied. What are my legal options now? Can I appeal or reapply?
So you have 30 days. It depends which if your case was denied with USCIS or if it was denied with the immigration court. With USCIS, once they deny it, the asylum application, they send it to the immigration court. So you do have the option to uh, basically redo this whole thing again with the immigration court. But if it was denied with the immigration court, you can appeal it to the Board of Immigration's Appeals, which the judges do tell you during the hearings. You have 30 days, though, from the date of that decision to do that appeal. If you do not file that appeal within the 30 days, there are exceptions. However, it's changed country conditions, ineffective assistance of counsel, and there are more extenuating circumstances with. But like I said, it depends on your specific situation and when your claim was denied.
Thank you. Next question is, how do I prove that I'm still in danger if the US government now considers my country safe? What kind of personal evidence can strengthen my case?
Well, I think I probably sound like a broken record, but definitely the mental health evaluations, country conditions articles showing attacks of people in similar situations as you were in your country. So, like for example, if your political party was continuously being attacked, or if your gender is continuously being attacked, or if you're a member of the LGBTQ community and there are others being attacked, and it's on the news and it's on the articles, the news reports, you can definitely submit those and your affidavits from yourself, affidavits from your family showing, explaining what's actually happening in the country in real time, friends, those in similar situations as you also in your country. If you know of people, they can also do affidavits explaining that they were attacked.
All right, thank you. Next question is, and this is our last question, I don't have government documents, but I do have support letters from my church and community members. Will these be taken seriously in an asylum case?
So I'm church and community members documents from here. If from the United States, when I say here, if you bring them for cross examination, they will be given more weight. So they will be considered. They may not be that they may not be considered that strong for your case because, like I said, they're individuals who are here. However, if it's support letters from your church and family members overseas from your country of origin, it will be given weight in your asylum case and it will be taken seriously. However, like I said, in many cases, if they're not available for cross examination, the affidavits are given limited weight.
Thank you. And that was our last question. That was an incredible session. Thank you so much for joining us, and a special thank you to our special guest, Attorney Bailey, for your practical and strategic insight. We hope this webinar helped answer your questions on asylum claims. Remember, at immigrationquestion.com, you can ask your immigration questions for free and get connected with a licensed attorney in good standing who can help you better understand your options. You may also qualify for a free confidential initial consultation. Visit our website to learn more. Don't forget, you can rewatch this session or listen to previous episodes on Spotify. Just search for Borderless Talk by immigrationquestion.com. Join us again on Friday for another enlightening edition regarding another burning immigration topic. Trust us, you won't want to miss it. Once again, thank you, Attorney Billy, and we look forward to having you back soon. Thank you so much.
Thank you so much. Thank you for having me, everyone. Good luck with everything that you're doing. I really appreciate you listening to me today. Bye.
And thank you.